morning. Good morning.
There was an ancient Chinese philosopher that said, the journey of 1,000 miles begins with the first single step. And in looking at what we are here for today, this is our 10th anniversary of a Black History Month event hosted by J4P Associates. While it's not 1,000 miles, it's a long journey because it seemed to have gone rather quickly. And if you multiplied the number of hours and days and seconds that it would take to get us from where we started to where we are, there are high school students here, so if you quicken math, tell me how many days would it be for 10 years, how many hours it would be for 10 years, and how many minutes it would be for 10 years. You'll be given a free lunch if you get it right, but I'm going to give you the answer, so it's open book. That equates to 3,650 days, 87,600 hours, and 5,256 minutes that J4P has been putting on these kinds of programs in addition to the other things that they do in the community. So today we are really, really proud to have some very, very special guests that will headline the program. I'll introduce them in a minute, but are there any elected officials in the audience that I've neglected to acknowledge? I saw Jerome Stevens representing us, U.S. Senator Ben Cardin. Is that McCoy back there? Okay, he's a Corey McCray, and state delegate in this area. And who else did I miss?
Our clerk of the court.
Lavinia Alexander, clerk of the Circuit Court.
Thank you and welcome. And we have with us Winston Wilkinson from the Governor's Office of Community Initiatives. He's leading with staff. But we want to also thank Medford Mills High School and their chaperones for coming. Thank you all very much. It's always refreshing to have young minds in the room. You're the future. I want to introduce Peter and Pat Handel. Peter and Pat are the property owners of all that you see around here, including the complex, and have been here for over a quarter of a century. Peter will have some words at the end. And then I want to introduce the J4P staff, Shirley Traub, Deidre Steinem. Who else is here? They're outside doing work. But we're very, very proud to be a part of this. And today, as I said earlier, is really, really special because we have with us some distinguished guests to headline the program today. And we have with us on my immediate left here, none other than the Chief Judge of the Maryland Court of Appeals, Chief Judge Barbera. Thank you so much for coming. Next to her is a man that needs little or no introduction in Baltimore. He's been around a while. He's an author and a notable attorney, A. Dwight Pettit. He's been engaged in a lot of activities here in Baltimore. So I don't think I missed anybody, but again, welcome. We're delighted to have you.
Constance.
Oh, how could I forget? How could I forget? Part of the J4P team and the man who wants to be the next mayor. Stand up, Carl. Of Baltimore City. Carl Stokes. Thank you, Becky. That was by design. I want you to be a man of distinction, Carl. But this is going to be a program of a conversation, and we want to start off by having Chief Judge Barbera come up and say a few words, and then we'll have Mr. Dwight Pettit, Esquire, to come up and say a few words, and then the program belongs to you. So, ladies and gentlemen, please give a warm welcome to Maryland's Court of Appeals Chief Judge, Mary Ellen Barbera. Thank you.
Very nice introduction. Good morning, everyone. Good morning. I begin with an apology. I I fought off a cold for about 10 days when my husband was coughing and sneezing and all the rest, and I woke up yesterday morning and my efforts went for naught, evidently, because I'm doing a little coughing and sneezing and so on today. So I apologize. From time to time I may have to take a sip of water. It is such a pleasure and a privilege to be here. Mr. Jennings is very persuasive, and it wasn't that I didn't want to say yes right away, but as I was telling Mr. Pettit, we're right in the throes of, I shouldn't use that word, right in the midst of the legislative session of the General Assembly, and so I'm spending, in fact, Clerk Alexander and I saw one another in the hallways of the, I guess it was the House of Delegates building just a couple of weeks ago, as we are fighting for more judges, and of course I'm always trying to defend the judiciary's requested budget, and I'm sure you can appreciate. So that was my only hesitation, about being here today. But I have to tell you, it is great to be here because I love meetings of this sort, particularly, and if every one of you would raise your hand, those of you, is it Milford Mills? Yes. Okay, I know Milford. I used to swim in the quarry out there. How many of you from the school? That's it. Okay, that's great. I'll be talking to and with you quite a bit in my remarks. So here we are on Leap Day, February 29th. I was at my daughter's father-in-law's birthday party. He was born on February 29th. So we celebrated his 21st birthday. The gentleman is 84 years old, and that was just yesterday. And we managed to squeeze this in on the last day of Black History Month and celebrating Black history. And again, for that reason, as well as many others, I'm so happy to be here. And I am delighted that we have students here this morning as part of the celebration, and to learn of the struggle, to learn more. You've already learned much, and we continue to learn every day, but we work also every day to overcome the challenges that remain for African Americans in these United States. Those who know the lessons of history are better equipped to lead change in the present, and that's why we are doing this in no small measure. I was born in Baltimore and I grew up here. I was a teacher for 8 years here in Baltimore City Elementary Schools, and even though I am a judge, I still teach today. Not today, but I teach at one of our law schools. Actually, it is the American University Washington College of Law, and I've been doing that since about 1993. So I love to teach, and I also love to learn. I'm keen to learn, and I look forward to and know I will learn today from all of you. As Mr. Jennings has mentioned, I am Mary Ellen Barbera, Chief Judge of the Court of Appeals. Now, I'll give, for the few of you in this room, and I apologize for those of you who already know this so well, but I thought I would take just a few moments, particularly for our students, because it's good to know these things. It's part of our governance and government to have an understanding of the court. So I'll describe briefly how it works here in Maryland, and we have the administrative judge of the district court here in Baltimore City, Barbara Waxman. Where are you, Judge Waxman?
She's over here.
There you are. I'm a huge fan of Judge Waxman. She does so much that's good for the court here in Baltimore City and for the people of Maryland generally, beyond the territorial boundaries of the city. It really, what you do and what you working with your judges and others who are frequent participants in the judicial process is huge, and it has spillover effect, not just again for the folks in Baltimore City, but statewide. So thank you, Judge Waxman. And I had to twist her arm to take the tough job, and fortunately for us, she is. We've managed to She keeps threatening to retire. I can have that. Okay, so we start, there are 4 levels of courts in Maryland, and we begin with, we call it the People's Court. It really is where a lot of the action is, the District Court of Maryland. It is, because we're an old state, and we go back hundreds of years, we're sort of an odd amalgam of how the courts were created, and we started with 1 trial court and 1 appellate court in Maryland back in the day. But I guess it was there was a convention in the late 60s that led to the creation of the District Court of Maryland. It is 1 unified court statewide, but has courthouses throughout the state. And as Al Collins, my friend Al Collins, I've known him for years, and you know far better than I that the district courts, often it is the state of Maryland is our landlord throughout the state, and so we have the district courts throughout the state, and that's where most of the cases are heard. But there is one thing that doesn't happen in the district court that does happen in the circuit court, and that's the way in which some trials are conducted. Not just by the judge, but by the folks, the men and women who find the facts. Do you know what I'm talking about? Anybody from Milford Mill? Who often decides the facts of a case at the trial level? Not the judge, but usually there are, in civil cases, there might be 6 people. I heard it, I think. Jury, yes. So at the district court level, only judges preside. And there are certain cases that begin and end in the district court. Some cases start in the district court and move their way up to the circuit court. And we consider the circuit. Hi, Judge Avery. How are you? Hello. Hi, Judge Weinstein. Hello. I'm seeing all these nice people, my friends. So they go from Judge Weinstein's court at the district court. There she is, Judge Weinstein, Hallie Weinstein. They, from time to time, will get to Judge Avery's court, Shannon Avery. I've known both judges for a very long time, and they're wonderful public servants and others. Okay, so then you have the circuit courts are where the jury trials are held, serious criminal matters, serious civil matters, family law cases are litigated at the circuit court level. And then, there's, as always is the case, there's a winner and a loser. And so that's where the appellate courts come in. And we have, there were not 2 appellate courts back in the day, there are 2 now. And not just ahead of the district court was the creation of what's called the Court of Special Appeals. And that is the court where every case where if the loser is unhappy with what happened at the trial level can go to the Court of Special Appeals and have a shot at having that case reviewed. And hello, Mary, how are you? Mary Abrams from our district court. And then we have the state Supreme Court. Now, there's only 2 other jurisdictions in the United States where the state Supreme Court is not referred to as the Supreme Court. That is the state of New York and our next door neighbor, the District of Columbia. So like the state of New York and like the District of Columbia, we are the Court of Appeals, not the state Supreme Court, but we operate as the state Supreme Court here in Maryland. The role of state Supreme Courts, and that includes, as I said, the Court of Appeals, the court on which I sit, is to determine what our Maryland law says and whether there are any constitutional concerns about what happened at the trial courts. And we look to our Maryland Constitution, right? My friends from Milford Mill. We look to the United States Constitution. We look to our Declaration of Rights. Cases that are decided by my court can be appealed if they have an issue involving the United States Constitution or its amendments, the Bill of Rights or the amendments that have followed. The 14th Amendment, which contains both an Equal Protection Clause and a Due Process Clause, is often the vehicle for raising important concerns that might begin maybe in Judge Waxman's court, or they might begin in Judge Avery's court, find their way up to me, and then could eventually go to the United States Supreme Court. Courts tend to follow the law as it has been, and we like to use Latin phrases in the justice system, and this is the doctrine of stare decisis. It has been, the thing has been decided. So that we courts tend is important, tend to follow the previous decisions of the courts. And that is a good thing to a certain extent. It's a good thing because people who are governed by laws need to understand that they can depend upon the law as it has been written by our legislature, our state general assembly, or the United States Congress, and decided by the courts. When a previous decision is either clearly wrong, though, or becomes wrong, when as a society we move forward, we become more enlightened, and the interpretation that was given by the court, the United States Supreme Court or the Maryland Court of Appeals, needs to be revisited and needs to be changed, courts can overturn earlier decisions. They can go beyond the doctrine of stare decisis. As our society develops and changes, so must our understanding of the protections of the Constitution and the law. Even the United States Supreme Court gets it wrong from time to time, realizing years and sometimes many years, sometimes it takes a long time, as we develop as a society, that an earlier decision was a big mistake. The 1857 Dred Scott decision. Those of you in Milford Mill, I hope you've talked with your teachers over the years about the Dred Scott decision. Not one that we're proud of as a country. And fortunately, it was overturned by subsequent decisions by the United States Supreme Court. You may recall from your history teachers and the books that you might have read in preparing for class, that was a really abhorrent decision of the United States Supreme Court. In that case, the court ruled against a slave who sued for his freedom and for the property rights of the slave owner. Today, we find such thinking to be absolutely, not simply wrong, but I used the word already, abhorrent. Because, of course, all men and women are created equal. The Declaration of Independence declared the equality of men to be a self-evident truth. Remember that? We all learned that in school.
Yes.
And we need to live the faith of it. This was not a universally held belief before the Civil War. And the Emancipation Proclamation that ended slavery, which was just the beginning, right? Just the beginning of the struggle for equality by African Americans. Even the passage of the 14th Amendment, I mentioned that earlier, containing the equal protection and due process clauses, that was passed in 1868. And that says, no state shall deny to any person within its jurisdiction the equal protection of the laws. Even that was early on and for far too many decades limited in its impact by Supreme Court decisions. So again, the work continues, and it continued through the Plessy versus Ferguson, the 1896 decision, separate but equal. That doctrine, of course, resulted in much that was unfair, if not downright brutal, around this country. Under the restrictions of separate but equal that so burdened them, courageous and determined African Americans, with others who saw the correctness of their cause, they undertook both civil protests and the legal battles to change the United States to keep the promises of its Constitution for all of us. After 50 years, a remarkable man, an African-American lawyer born right here, and we have many, many fine lawyers in our city and our state. I'm speaking of one in particular, born right here in Baltimore, would lead the way to convince the United States Supreme Court to begin to undo the change that was done to the civil rights of African Americans. Any idea about whom I might be speaking? His name was Thurgood Marshall, exactly. And I just learned that our own Dwight Pettit was represented by the Honorable Thurgood Marshall when Thurgood was still a lawyer before he attained that most amazing position that, of course, we all know, and I'll speak about in a moment.
That's awesome.
It is awesome. It is. In 1934, you may know, Thurgood Marshall represented a man who, despite his excellent academic record, was refused admission by the University of Maryland School of Law because of his race. Donald Gaines Murray was his name. Marshall argued that Maryland's segregation policy violated the separate but equal doctrine of Plessy versus Ferguson. Remember that case from the late 19th century? Because the state did not provide equivalent opportunities for education for African Americans and Caucasians. The Maryland Court of Appeals agreed, good for my predecessors on the Court of Appeals, writing, and this is the words of the opinion, compliance with the Constitution cannot be deferred at the will of the state. Whatever system is adopted for legal education must furnish equality of treatment, and it must be done now. Marshall founded in 1940 the National Association for the Advancement of Colored People, the NAACP's Legal Defense and Educational Fund, and I am so pleased that Sherilyn Eiffel, I believe she's still the, yes, I was at a conference, I knew her when she was a professor at University of Maryland School of Law, and I hope some of you and some of the students here that you're thinking about a career in the law as a possible option for you. It's a wonderful profession. It's an opportunity to do good. It's an opportunity to advance the causes, whether of civil rights or other concerns that we still need to work on. Sherilyn Eiffel was at a conference at Stanford University, and I happened to be there myself, and it was such a pleasure to see Sherilyn. I hadn't seen her a while since she attained that very important position. Marshall, as a lawyer, Thurgood Marshall founded, as I said, the Legal Defense and Education Fund, and he would argue, this is amazing, ladies and gentlemen, he argued 32 cases before the United States Supreme Court and won 29 of them. That is virtually unprecedented. I mean, it's just astounding. And he won the first of them at the age of not 62, not 52, not 42. He was 32 years old. Now, that was news to me. I knew he was a young man, but 32, that's really impressive. So the NAACP Legal Defense Fund lawyers, led by Thurgood Marshall, focused upon getting the court to re-examine and ultimately overturn Plessy versus Ferguson, that separate but equal doctrine. And the Supreme Court did. In 1954, the court struck down separate but equal in educational facilities. And what's the case? Come on now, folks. Yes? Brown versus Board of Education, absolutely right. And other cases extended that, extended the doctrine, and we're all, that's an example of mistakes being corrected. And we keep that in mind as we move forward. These victories inspired civil rights activists around the country to push harder for change. The Reverend Martin Luther King Jr., of course. Rosetta Parks, who refused to give up her seat on the bus, of course. The thousands of African Americans who then boycotted segregated bus systems at risk to their personal safety. A 16-year-old Dunbar High School student. His name is Robert Mack Bell, one of my personal heroes, who protested discrimination, and for his efforts at a sit-in at a lunch counter in downtown Baltimore, I believe it was, he was arrested for criminal trespass and he was fined $10. Now the fine was symbolic, wasn't it? It was symbolic, a small fine, but his case went all the way to the United States Supreme Court, where he was represented by still then Mr. Thurgood Marshall and Miss Juanita Jackson Mitchell, also from Baltimore, also a trailblazing lawyer in her own right. And I had the privilege of meeting her. I was talking to Mr. Pettit earlier, probably not too very long before she passed. And, it was such a privilege to meet her. He and his classmates appealed their conviction all the way to the Supreme Court in Bell versus Maryland. You should read it if you have not. There's an important concurring opinion where really all the good language is. That's really where the powerful language is if you read it, because actually the majority opinion just sent it back to the Court of Appeals, and that's often the way it is with cases, by the way. To cobble together a majority, I have the opportunity and challenge to do it on my court. You need the majority of the folks who are sitting on the Supreme Court. Do you know how many justices there are on the Supreme Court? I have 7, 9. So for a majority you need 5. In my court there are 7 of us, you need 4. Often the majority decisions are kind of, they seem to be a little this, a little that, a little something else, and what do you suppose that is? To get 5 votes for the bottom line, for the thrust of the opinion. But the really powerful, passionate words are often in the concurring or dissenting opinions. So, anyway, to fast forward, it wasn't too very long before Attorney Thurgood Marshall became Justice Thurgood Marshall, and I had, again, never the privilege to appear before him, but the privilege of being in his presence as he sat on the United States Supreme Court, because my job took me to that court to watch court's arguments. That young student whom Justice Marshall represented before he became Justice Marshall, Robert Bell, I hope all of you know, I know many of you in this room do know as well, and perhaps better than I. But if you didn't know, those of us from Milford Mill, Robert M. Bell went on to attend Morgan State University. His conviction for trespass was finally overturned, by which time he was a law student at Harvard Law School. Graduating in 1969, he would be a trailblazer himself, becoming a judge on the district court in Baltimore in 1975. And I think he may have been 32 or perhaps 33 or perhaps 31, but he was a young man. He had caught the eye of many, many folks. He has I had the privilege of serving on the Court of Appeals with him. He served on the district court, then the circuit court, then the Court of Special Appeals, then our state Supreme Court, the Court of Appeals. And in 1996, he was appointed Chief Judge of the court, the first African American to be Chief Judge, and the administrative head of the 3rd branch of government here in Maryland. He served until his retirement at the age of 70 in 2013. Now, as the first woman to be appointed Chief Judge, I'm so proud and honored to follow in Chief Judge Bell's footsteps. Like Justice Marshall, Chief Judge Bell changed the face of the Court of Appeals forever. He understood personally and intellectually the urgent and crying need for access to justice and for the full appreciation of equal protection under the law. It infused, ladies and gentlemen, I saw it, and I'm sure those of you who know him can imagine this is so. It infused everything he did for the courts, for the judicial branch, and for the people of Maryland. And by the way, I do get to go to conferences of Chief Justices around the country. He is a hero nationally. We are so proud of Chief Judge Bell. And I'm also proud that the Maryland Court of Appeals looks so much like the population we serve. I mentioned that there are 7 of us. At this moment, 5 of the 7 judges on the Court of Appeals are women, and 3, thank you, and 3 of the judges on the Court of Appeals are African American. Isn't that wonderful? Though judging should be blind in the sense that no one is above the law and all of us should be treated equally, I am a firm believer that it is our collective experience, what brought us to the table, as it were, you know, the education, the life experiences that help to make the collaborative decision-making of any appellate court all the better. Without breaching the sanctity of judicial conference, which it is, you know, top secret what we talk about, when with the 7 of us, we close the doors and it's only the 7 of us. I can tell you that the amalgam of voices makes for better decisions. At the end of the day, we as a country benefit from the amalgam of thought and the viewpoint that comes from the wonderful difference that is us. Different voices are crucial. As a community, we must enlist the help of every one of us, everyone in this room, our neighbors, our friends and family, to challenge that which continues to remain unjust, to break free of what one might call the status quo, and to be bold, to take bold steps to promote and protect the legal rights of all women and men who do not sit at the table of equal opportunity. There's much work to be done, but it can be. It can be done. It's being done by good people in this room and elsewhere each and every day. Justice Thurgood Marshall did not lose hope because he had faith in the rule of law and confidence that our Constitution and laws would keep the promise of equality in our democracy. In 1987, on the 200th anniversary of the Constitution, he noted that it was, at the outset, not a perfect document. It had flaws and needed to be amended right away, and it was. That's where our Bill of Rights comes from. And over time, we have had amendments that have improved life and justice in the United States. He wrote then, in 1987, and I'm quoting Justice Marshall, "Some may more quietly commemorate the suffering, struggle, and sacrifice that has triumphed over much of what has gone wrong with the original document, and observe the anniversary with hopes not realized and promises not yet fulfilled. I plan," this is Justice Marshall, "I plan to celebrate the bicentennial of the Constitution as a living document, including the Bill of Rights and the other amendments protecting individual freedoms and human rights." He may have been thinking, as I often do, of the Reverend Martin Luther King Jr., who urged all of us to remember, and I hope, if you haven't heard this before, that you take this home with you. The good Dr. Reverend Martin Luther King said, among many fine words, "The arc of the moral universe is long, but it bends towards justice." I will close on this leap day by urging that we do just what the day suggests. We must not just today, but every day, make the leap. Make the leap of faith and commitment to bend that arc closer toward justice. Thank you, Mr. Jennings, for including me this morning.
Thank you, Judge. It's been enlightening, and we look forward to the Q&A from the audience. Next, ladies and gentlemen, we have a distinguished attorney from Baltimore, and he really doesn't need any introduction. He's an author. He's well known among all circles in Baltimore. A. Dwight Pettit.
Good morning to everyone. Good morning. I had the opportunity to be here last year before this distinguished body at the request of my good friend Carl Stokes, Councilman Carl Stokes, candidate for Mayor Carl Stokes. And it gives me great honor to have the opportunity to come back before you on this auspicious occasion today. Chief Judge Barbera took everything I was going to say because I was going to give you a history lesson in terms of the judicial process in America and Maryland, which she has just so perfectly delivered. So I'll try to fill in some of the blanks that the Chief Judge may not have been is totally specific, and bring us up to a little bit more contemporary times also, if I may. I wrote a book under color of law, and the reason I spoke about the book briefly, and the reason that I talk about the book now is because I argued in the book, but before I argue in the book, let me say, the book was dedicated to my father on his dying bed. And I promised him that I would tell our story, which is incorporated in some of the things that I will say to you today. But I wrote the book also as to a warning in terms of the body politic of America, that America was retreating from the promises and the commitments that it made post-Civil War to the newly freed slaves, and then was revisited in the civil rights movement of the 60s. And that now we find ourselves in a moment of apathy, and as the Chief Judge was saying, we were saying a while ago when we were discussing this, sort of waiting or sitting on our laurels, enjoying the victories of yesterday, while we find that those things are being dissipated today and put in reverse. There was a man by the name of Grant, who was President of the United States. Now, I never understood why Grant doesn't get the publicity that I believe he deserves. Grant was General Grant, who led the Union forces in the Civil War. And Grant also was appointed by Lincoln to head up the Reconstruction that was taking place in the South. And Grant would later become the President of the United States. And Grant observed in the South, particularly, that the atrocious behavior that was taking place in relationship to the newly freed Negro, quote unquote, that he went to Congress, or had persons go to Congress, and they passed what was known at the time as the Ku Klux Klan Act. And what the Ku Klux Klan Act was legislation that allowed the federal courts to in fact have jurisdiction, both criminally and civilly, in the South. The civil legislation was known as 42 U.S.C. 1981, 1983, passed in 1871 by the U.S. Congress. I bring that up today because that is the main sword of the civil rights movement, and the jurisdiction for the civil rights movement and the Justice Department to intervene in civil rights issues that we know and argue today. And so if you come up through history, that piece of legislation and others that we shall discuss were paramount and tremendous in the advocacy of the rights beyond, as the Chief Judge just said, beyond the 13th, the 14th, and the 15th Amendment. And so when we look back at Marshall, and let me, before I talk about Marshall, just let me say, Maryland is a relatively small state, but the impact that Maryland has had in terms of this national history and civil rights is unbelievable. When we look back at Frederick Douglass out of Maryland, we look back at Harriet Tubman out of Maryland, we look back at Thurgood Marshall out of Maryland, we look back at Clarence Mitchell Jr. out of Maryland, we look back at Juanita Mitchell, first attorney out of the University of Maryland, out of Maryland. Lily Mae Jackson, national president of the NAACP, out of Maryland. And all of these great people were the inspirational movers and shakers and bakers in the civil rights movement. But what is even more spectacular and definitive in the context of this discussion today, which I understood to be the impact of the Maryland judiciary in terms of civil rights, that we know that Marshall came out of Maryland. And let me just tell you something about Maryland that the Chief Judge may have missed, and if I'm repeating myself, I'm sorry. But Marshall applied, after coming out of Lincoln University, applied to the University of Maryland Law School and was, well, I'm sorry, correct me. He wanted to go to the University of Maryland Law School, but he knew it was segregated, so he never applied. So instead, he went to Howard University. And under the tutelage of some of the great professors of Howard University, he studied law. He comes back to Maryland, and one of his first cases is a man by the name of Donald Murray. Donald Murray had applied to the University of Maryland and been rejected. And Thurgood took that case to the Court of Appeals of Maryland that declared under the separate but equal doctrine. Now notice he's shifting now. He's going back to separate but equal, which the Chief Judge had just discussed was bad law, but Thurgood used it to make good law. And the University of Maryland became integrated. And then we go to Bobby Bell out of Maryland. And Bobby Bell, as the Chief Judge just indicated, would be arrested advocating his civil rights in 1960. And the Court of Appeals would uphold his conviction for trespassing. And that predated the 1964 Civil Rights Act. But Maryland was ahead of his time. Bobby Bell was ahead of his time. The criminal sanctions were in fact vacated. This was again Maryland back before the United States Supreme Court. And then of course, as the Chief Judge just alluded to, we would have Brown versus Board, Topeka Board of Education, which would change the whole national movement in terms of civil rights, because what Brown versus Board did, ladies and gentlemen, it just didn't open up education. It was the initial blow in terms of equality and the enforcement of the 14th and the 15th Amendment for this nation. And Brown versus Board, which came down in 1954, would in fact open the gateways for integration of the quote-unquote the Negro American. And so all these cases and the leadership and the litigation. Now let me go back. Well, I'm not going to get ahead of myself. So Brown versus Board opens the stage. And after Brown versus Board, after the Murray decision, Thurgood comes back to Maryland. For guess who? Yours truly. And he, with Juanita Jackson Mitchell and Jack Greenberg and Tucker During, take the case of Pettit versus the Board of Education of Harford County. Because the state had argued that I was intellectually inferior to white students, and therefore they wanted to protect me from the destruction that would be rained upon me by being put in a white environment. And the judge was the Chief Judge Roselle Thomas. And I understand that he and Thurgood got into quite a few unsavory words, but that's another story. But anyway, we win Pettit versus the Board of Education of Harford County in 1960. And I am ordered into Aberdeen High School, of which the suit was brought in 1958. I enter in 1960. But we take that a step further, if I may. I had no problems at Aberdeen High School. That's the high school of Cal Ripken. Cal Ripken being there, of course, after it was integrated. I had no problems, ladies and gentlemen, because I was an athlete. And I often say, if you can kick the ball, throw the ball, catch the ball, hit the ball, run the ball, or knock somebody out, America will accept you for your athletic ability. And so I had no difficulties. The kids loved me, the teachers may not have, but I got along fine. But my father was an electrical engineer at the Aberdeen Proving Ground, a scientist. And they told him that he would never be promoted again. That he would never achieve anything because of what he had done in the educational system of Harford County. And when he'd come to work in the morning, they'd play rebel flag. The rebel flags would be in his office. When he'd walk in the door, they'd play Dixie. when memorandums would go around for signatures, his would be admitted. He had no secretary, he had no facilities, and he was constantly tormented. And Juanita Mitchell, this great lady, was his lawyer also. And she took it all the way as far as you could take it with the Department of the Army, and they found that my father was being discriminated against, terribly and horribly, openly in defiance of law. But remember, Title VII was not passed, for equal employment opportunity, was not passed until the Civil Rights Bill of 1964. And there was no provision in Title VII for award of back pay to federal employees who might suffer discrimination. And so the Department of the Army said, yes, Mr. Pettit, you've been discriminated against. You've been denied promotion for 12 years at that time, and we're very sorry. And guess what? When a promotion comes, an opportunity comes, and if you are among those qualified, we will give you preferential consideration. Thank you, goodbye, and have a good life. And I'm a very, very religious individual. I remember laying in bed one morning, and I was reading the Washington Post. And I saw an article where a man by the name of Paul Tagliabue. Paul Tagliabue would go on to be the NFL commissioner. And I saw that he had a case in front of the United States Court of Claims, which is second only to the United States Supreme Court. Chief Judge Barbera was telling me about the numbers of judges. They had 7 federal judges on the U.S. Court of Claims. So I woke up, I told my wife, and I called Mr. Tagliabue, who was a very nice man. And he allowed me to come to his office, the largest law firm in the world, Covington and Burling. And he allowed me to go through the papers and what have you, and I brought suit. Now watch this. I had the opportunity to have finished high school that I wasn't qualified to go to, remember? I had the opportunity to finish undergrad at Howard University. I had the opportunity to finish law school at Howard University. I had to come back and had the opportunity to practice law or pass the bar. Well, state of Maryland, we'll talk about that in a second. And I brought the suit, and the court accepted the suit of Pettit versus the United States and put it on the docket as a primary case for the nation. And so in 1973, by a 4-3 decision, I was walking down the street, judges from the district court. I was coming from the district court in Wabash, and I saw the TV trucks pulling up and everybody running toward me. I was scared. I didn't know what was going on. And they said, Mr. Pettit, you just won Pettit versus the United States. And the court appointed me to monitor and supervise the Department of the Army in terms of the provisions and the back pay and all to be awarded to my father. So I had the opportunity to finish all the matriculation of education and take his case. And one of the beauties of that case, and I'll tell you what it stood for, but as I would walk into a federal courtroom or a federal administrative hearing, the judge would say, Mr. Pettit, do you have anything to do with Pettit versus the United States? And I would say with glee and with a smile on my face, George D. Pettit is my father, and I was my father's lawyer. Wow. And so that case would go on to establish the parameter for the nation in terms of the but-for test, the test that was required to in fact prove discrimination in a federal courtroom. Meaning if you laid out qualifications and a person was qualified, the burden shifted for the defense to come back and say why the promotion was not granted. And that was in the standard in the nation for many, many years. But it also, believe it or not, what President Obama argues today in terms of executive orders. Pettit versus the United States, the foundation and the legal argument was that Congress has not acted, but guess what? Presidents of the United States have acted all the way from Roosevelt and Truman. An executive order should be law, and the Court of Appeals, in a 4-3 decision, accepted that argument. When the Supreme Court, we briefed in the Supreme Court, but ladies and gentlemen, I had my apprehensions about the Supreme Court at the time. But the case settled outside of the Supreme Court before the Supreme Court could rule. So we still don't know today the effect of executive orders, although I suspect we will find out at some point in time, with the Obama administration, continued to use that vehicle. But that was Pettit versus the United States. And then I had the opportunity to come home and have difficulties with the Maryland Bar Association. They were passing one black attorney at a time at that point in time, and maybe two. In 1 year, they did, in fact, pass 5. So I brought the next big case that I brought was Pettit versus the Board of Law Examiners here in the United States District Court. They finally dismissed the suit after I passed the exam, saying the suit was moot. And so in my era, I had the opportunity as a lawyer, as a plaintiff, to be the plaintiff in Pettit versus the Board of Education, to be the lawyer in Pettit versus the United States, and again to be the plaintiff in Pettit versus the Board of Law Examiners. And then I had the opportunity to come back. I left the Small Business Administration, where I was on the trial team for the national office. I was the second African American hired. And I had the opportunity to come back and litigate in the courts of Maryland. And at that point in time, ladies and gentlemen, we had a very, I would say, not very, but a very, I would say, marginally speaking, a good progressive federal court. And such judges as Judge Miller, Judge Northrop, Judge Harvey. I had the opportunity, Judge Shirley Jones. I had the opportunity, Chief Judge, to appear before all of these judges during the civil rights time and the civil rights movement. And fortunately, because the nation was ready for it, I had the opportunity to win case after case after case in terms of Title VII, because I had a national reputation. I had the opportunity to win cases involving discrimination and what have you. So I stayed into the federal courts until the event of Mr. Reagan. And when Ronald Reagan came about, I began to feel the shift in the mens rea of America. I began to feel the shift in terms of the courts of what was acceptable and popular was no longer acceptable and popular. Even though Title VII was amended to include jury trials and to include women, the shift in America had taken place. But I was very fortunate. We had a very liberal, I might say, liberal Court of Appeals, Chief Judge. And so several of the matters that went up before the Court of Appeals and the Court of Special Appeals, we were quite successful. One that I remember very, very distinctly was a case involving Mr. Murphy. And now I bring this case up because of its importance. Mr. Murphy was stopped in Elkton, Maryland, and his car was searched. And in his car, they found $71,000. They seized this car. No, I'm sorry, they kept letting him have his car. They seized the money, state troopers, and he didn't even have money to get back to Baltimore to get across the bridge. They took everything but $700, so when he walked to the police barracks to complain about them taking the $71,000, they took the $700. And so we brought the action in Elkton, Maryland, a civil rights action in the early 1970s, or the late 1970s, in Elkton, Maryland. And we had a judge by the name of Cole. Judge Cole was the circuit court judge. Never spoke to me the whole 3 days of the trial, but he ruled the right way. He ruled that there was no probable cause for the stop and argued that the money should be returned. Now, the money being returned was another issue, that we would go to the Court of Appeals and back to the federal courts. I don't think he ever got the money, but that's not the issue here. The issue was the fact that that case, in my opinion, was the precedent for the cases that were brought by the ACLU and the NAACP later about profile stops on I-95, in which they were successful. And the state had to turn over certain records and certain numerical evidence as to black and white and stops and whether or not those stops were in fact profiled. So I had a great run in the 70s and the 80s in the federal courts and the state courts. And I would be amiss or remiss if I didn't just mention some of the outstanding jurists that may not have been on the courts, but judges, or he became a judge, Ken Johnson, later on the circuit court of Baltimore City, Billy Murphy, Norris Ramsey, Juanita Jackson Mitchell, of course, Gerald Smith, Judge Watts. And these lawyers toiled in the federal and the state courts in the years during the 1970s and the 80s, fighting civil rights cases on a daily basis. It wasn't popular, but they did it. And then the judiciary, with these attorneys, helped to change the image of Maryland, because you got to remember, the chief judge talked about Taney. Taney had become infamous in the nation because in the Dred Scott case, he ruled that no African American or no Negro had any rights that a white man was bound to respect. And so Maryland had become infamous. And so I was able to watch these great attorneys. Even in my case, Pettit versus the Board of Education of Harford County, Thurgood Marshall didn't raise Brown versus Board of Education because the chief judge didn't want to hear it. What he raised was Plessy versus Ferguson, and said Plessy versus Ferguson said the schools have to be equal. And where Pettit is going to the school of Negro, school is not equal to the white school. And so it was on that theory where they had to back up and dribble and change momentum and change places and change directions that they were able to win these cases through the creativity and the brilliance of their litigation process. And so Maryland has a long history when you go back to Taney and when you go back to Marshall. But it has a long history that also was a history of fighting and so forth when the 1964 Civil Rights Act became law, when the 1965 Civil Rights Act, and I have to mention, ladies and gentlemen, Juanita Jackson Mitchell was married to a man by the name of Clarence Mitchell Jr. And Clarence Mitchell Jr. doesn't get much play, but when you see, in terms of the national parameters, when you see Johnson, Lyndon Baines Johnson, my favorite president, when you see him signing the 1964 Civil Rights Act, and you see him signing the 1965 Civil Rights Act, those bills were constructed and orchestrated from a great part, or to a great part, by Clarence Mitchell Jr. out of Baltimore, because he was the chief lobbyist for the NAACP. And as chief lobbyist for the NAACP, he was referred to as the 101st Senator of the United States Senate, because he stayed in everybody's chambers, constantly pushing the black agenda for Dirksen and all the others, and Lyndon Baines Johnson and Ted Kennedy, who would, in fact, this would become law through their efforts. So Maryland has a tremendous history in terms of its judiciary. And it has a tremendous opportunity, Chief Judge Barbara, to continue to go forward. And I am so proud that you are the Chief Judge. And I see that we are still, with the new appointments, in terms of the items that you mentioned, in terms of the ladies on the court, in terms of the racial breakdown, in terms of the progressive persons on the court. I have great confidence that the Maryland Court of Appeals and the Maryland courts in general will continue on the progressive path that it's on, in spite of the current Supreme Court, which is now going to be a major issue, which I hope to be delivered to the electorate in terms of whether the Supreme Court is going to go to the right or move back to the left. And so I'm very, very honored to have the occasion to appear with you today. And knowing your rich history, I Googled you this morning also. I am sure that the court will continue to move in a positive manner. Thank you so much.